Supreme Court verdict on Kogi elections, what we're discussing tonight. We're looking at if this at all is a triumph for democracy, even though we need to hear what the Supreme Court, the reasons why they gave that judgment, and that will be next week. But before then, we're having some intelligent discussions here as to whether there's a lacuna in the Constitution that needs to be amended as far as this electionary matters are concerned, or if this has not set us on a wrong precedence as far as subsequent cases are concerned. Gentlemen, we left off on this issue of lacuna and precedence.
Yes,
you see it more like a policy, like you said.
Policy judgments.
Other than relying on the interpretation of the law.
Clearly the facts of the case. And I think there's a lacuna.
There is.
It's unfortunate. Let me address the issue of lacuna. Let me address the issue. If you look at section 181, there is a lacuna. Because that one says, once the governor has not been sworn in, for whatever reason, and is dead, the deputy or the honorary will take over. Automatically become governor. They never envisage the fact that on the day of election, where you are still counting, somebody will slump and die. I think that maybe need to look at it critically. But in interpretation of statutes, they are literary and they are mischief. You can look at it. Why did the drafter of this law talk about even deputy governor automatically becoming governor if the governor should die in the event of not yet sworn in? You understand what I'm saying? They never have. We can expand it now. Although so
this is good. This is good for us too. I mean, it opens an opportunity for a debate like this.
Unfortunately, they did not. The decision was not fair enough. The decision is not fair.
Okay, before you take on whether this is a policy judgment or otherwise, let me ask a question.
It's not a policy judgment.
Okay, hold on. If
it is a judgment that is anchored purely on law, and that's why I don't bring it up on. First,
let's assume that the candidate won and he was declared.
Yes.
And shortly after that, he died.
He died.
Immediately he dies after he has been declared, because the word there is before inauguration. That is the operative word.
But let's even assume before inauguration.
Before inauguration.
But he has been
automatically.
But
the running mate becomes the governor.
Yes. So what has changed in this case?
What have changed?
Or what's the difference?
Why can't they go and bring somebody from outside to be the governor?
The operative word is the inconclusiveness of the election.
There has not been something.
At what point was that election eventually conclusive?
It was declared inconclusive on the 21st of November 2000.
No, the process at that
not
point, even the date. I'm talking about.
That's the point I'm trying to tell you.
At what point did this election become conclusive now?
As at the time it became conclusive was after the 5th of December, when the supplementary election was conducted.
From that 19 poll, 19.
That election was a mere formality.
From 21 local of the 20 local governments.
Yes. Of course.
But that's not for the 19 local governments. Just
because
for 19.
I told you from the beginning that the political party was holding these votes in abeyance.
Okay.
In view of section 1. In view of section 221 and 222 of
it's
the
running on that platform.
Okay, so explain.
Because it is on the platform of the political party.
I said I was going to give you an opportunity to explain whether it's a policy judgment or something based on
if you look at the INEC approved guidelines and regulation for the conduct of the general election 2015, particularly pages 22 to 23, paragraph 4, section M. So the returning officer in directing as follows: where the margin of win between the two leading candidates is not in excess of the total numbers of registered voters of the polling units where election was cancelled or not held, in excess of the margin of win between the leading candidates, election is inconclusive.
Okay.
Now,
it is on whether it was conclusive.
It is on that basis. It is on that. I've given the facts.
Argument that too.
I've given the facts. I've given the law.
Hold on.
I've given the facts already. I've given the facts where I said that the margin is
41,353.
Yes. God bless you. Yes. Now, having said that, you will now see that
the margin was
less than that of the registered voters in that 19 polling units of the 21 local government areas.
You know they are not
to 5,000. It is premature at that point because you will not know whether everybody will come to vote or not.
Everybody will come to vote. They don't vote for the same candidate.
The law is so clear the guidelines are so clear. You cannot read outside meaning what is contained or the clear provisions
that
of the
is
law.
why
and that's what we are doing.
The Apex Court supposed to read.
Now look at it again. If you look at
the section, they have the power to do that.
Section 36.
They are the only one that have the power to
interpret. It deals with the withdrawal of a candidate and replacement of a candidate. And the operative word there is the commencement of the pool, doing the commencement. Now, they have commenced.
Yes.
And in the course of it, they invoked the relevant provisions of the electoral guideline and said this election is inconclusive. As at the time that a pronouncement was made, who actually suffered it is even the APC.
Yes.
One could say, sorry, I say,
you should know that
Abubakar Audu.
Yes. You should know because of this problem is that APC themselves have in-house problem.
If he had not
ordinarily, they should be happy
and only
that their deputy is alive to take over
the governor.
Okay, let's see how today. Let's see to what extent our viewers have understood what we are discussing and see. Let's give you an opportunity to come in at this point. If this is according to Ima Okochwa, okay, if I got that right, forgive me if I didn't. If death is a ground for substitution against nature, then other reasons will soon be used to. Note that.
No, somebody sent one.
Mantu John says a popular candidate can be used only to gain votes for a favored candidate by the party.
Yes. And then it can happen to him before declaration. Before
hold on.
Let me read more too. So we can have
sentiments.
Let me do that.
Sentiments. You don't bring unnecessary sentiments.
Let me do that more
too.
too.
Clear.
Let me do that more too.
Clear. That's why we are arguing.
You interpret law to suit the intention of the lawmaker. So that the intention of the lawmaker will flow. The intention of the lawmaker is that a political party will sponsor a candidate from beginning to the end of the election.
Is that the true interpretation or
okay, guys, hold on. Let me read out this more.
Even by literal interpretation, that's not correct.
Let me read out this by Abdul Rahim, I should say. Sorry. We must commend Faleke and Wada for going as fast as the Supreme Court, as they've helped in redefining the Constitution. Because I mean, by 30th, that's next week, we're going to see a lot of things that will open up the space as far as this kind of issues are concerned. And I think I'm anticipating a good precedent.
And that's why I said that this judgment has set up a new precedent. And that is law in itself.
But people have suffered.
You know, we are talking about.
You see, there is no way
for democracy.
Change.
Someone saying,
with due respect that I think the executive.
So when you want to redefine the position of the law,
Ima Okuchwa is furious. He says the Supreme Court is not infallible. The decision is curious, very curious, according to him.
No, he has his opinion. But the point
I want to believe
it is the issue of sentiment.
I want to believe that there is intimidation.
I want to believe there is even an
we
must follow the law the way it is. Even if you are the only
there's executive intimidation. When the voice, our president has gone to the United Nations again. You go there and said the judiciary are giving me a problem. They just want to please him. If you look at that particular provision, it is clear.
Section 181 envisaged a completed election.
You are the one.
Having agreed that
you are not the court.
It is not the political party that declared the party to be inconclusive.
That's Section 181, which is based on conclusive election.
What about Section 187?
I think that's the lacuna that may have been exploited.
Let me tell you, one of the major positions canvassed by Faleke's lawyer, was Section 187. And that Section 187, the fact is clear. At the time Bello came in for that final part of the election, Faleke has resigned. And the provision of the Constitution 187 is that you cannot
run alone.
You cannot run alone without your running mate. He has no running mate. On that basis, they ask the court to nullify that particular position, that election. Only we are yet to see the reason.